You listen. Good evening. Please take your seats. We're going to start, and we're going to go absolutely superficial into this topic because it's such a huge topic. We won't even be able to scratch the surface, but we'll try and we'll leave some marks, hopefully. My name is Paola Antonelli, and you're here for the MoMA R&D Salon number 11. Many of you are veterans. Some of you might be newbies. So just a very brief introduction. MoMA R&D is an initiative, not really a department, because it's half of me and then it's Paola Petkova. And what we do is we do a lot of R and very little D so far, but the R is particularly interesting because it focuses on the intersection of an institution like this museum and the real world. We believe that museums could be the R&D of society, that a lot of experiments could be tested here that then could percolate down into the world at large. And we try to think of what those experiments could be. And in particular, these salons, this is the 11th one, deal with topics in which the museum has some expertise or an investment that has pushed its staff to become semi-experts, but there are also topics relevant to the outside world. And tonight we're going to talk about a topic that is huge. We're going to talk about fair, unfair, copyrights, and us. Who's us? Well, it's you in the audience. It's artists, it's curators, it's scholars, it's manufacturers of furniture and PRs for furniture manufacturers. It's many different parties that are involved in intellectual property and that deal with things, with content, as it's called, with music, with art, and that are trying to grapple with this huge issue, which is the idea of fair and unfair use. The idea of copyright is centuries old. We go back to the Statute of Anne in the UK in the 18th century. But the emergence of new media and of the internet has precipitated the discussion that had been going on already for centuries and made it even more complex and interesting. And in a way, copyrights law is the bridge between the creative world and the legal world that is most trafficked, probably. I don't know one artist that is not passionately interested in the idea of copyright and intellectual property. And the lawyers that deal with intellectual property and copyrights are artists unto themselves, as you'll see tonight. It's quite an interesting topic to be dealing with. So this is a doy kind of statement that I love very much by Thomas Jefferson. If nature has made one thing less susceptible than all others of exclusive property, it is the action of the thinking power called an idea, which an individual may exclusively possess as long as he keeps it to himself. I like that. But the moment it is divulged, it forces itself into the possession of everyone, and the receiver cannot dispossess himself of it. I'm sorry for all the him and he, but no matter what, it's really a doy statement, and it's a statement that is very much at the basis of so many of us here today, I'm sure, and it's a statement that is part of our practice. Well, to begin, it's a very murky world, and our attorneys here tonight will help us understand. But tonight we're going to talk mostly about copyrights, but there's also trademarks and patents. And if you've had a chance to read some of the reading references that we sent you, you'll know that the difference is that trademarks protect source identification and, in a way, help a manufacturer or merchant identify its good or services and distinguish them from others. Patents protect new and useful inventions, and we know how complicated that is for architecture and for design. Copyrights protect original creative expressions, and a copyright seeks to promote literary and artistic creativity by protecting for a limited, at least it should be limited time, what the US Constitution broadly calls the writings of authors. We will keep a pretty American perspective tonight, just because the world is so complex when it comes to these laws. But the whole diatribe is really focused on a very big cultural division. The only one that we know, I'm sure there are even more cultural division if one goes beyond Europe and the United States, which is our very limited world. But the Anglo versus Euro idea that copyright, that's the Anglo version, is focused on the audience and its hopes for an expansive public domain. And instead, Euro, authors' rights, France mostly, in contrast, have targeted creators and their claims to ensure the authenticity of their works. no matter what, there's a lot of idealism on both sides, and idealisms that have led to also the formation of a hero system. And, our heroes, in the art world and in a place like New York are the people that were at the basis that founded Creative Commons, Larry Lessig and all of his collaborators. And of course, there's also big heroes like Aaron Swartz that actually, one could say, died because of his idealism and because of his belief in free access. In open access culture. So it really is a big issue. And tonight we're going to talk about what copyrights are and who are they here to protect, and we're going to talk about some of the nuances that they entail. Anyway, the idea is that no artwork comes from nothing. I remember when I was working in fashion as a teenager in Italy, and I was pondering whether to go in the fashion world. Thank God I didn't. But I remember that I read Roland Barthes' The System of Fashion, in which he said very cynically and wonderfully that nothing is new, that there's already a catalog of all sorts of garments that are then recombined into a novelty. Okay, that's a departure point that is very strong. And Manet himself said that his Déjeuner sur l'herbe was inspired by Renaissance paintings. And then we know that this is one of the most appropriated and reused paintings ever. We see here Picasso's Déjeuner sur l'herbe, but then we also have Seward Johnson and Micheline Thomas. And it's really interesting because this really strong and famous image gets appropriated and reinterpreted to convey the different messages and the different agendas of all the artists. And of course, there's Bow Wow Wow and also The Simpsons. Very famously, The Simpsons had a mission to communicate and an agenda to pursue, and they did so in episode number 10, The Crêpe of Wrath, in which they deal with France. Of course, fashion is always so original. So Mario Sorrenti for Yves Saint Laurent, Inez Van Lansverde and Minot Matadin for Dior. So we have plenty reinterpretation of Déjeuner sur l'herbe. And but the stereotypes don't stop at images. The platitudes that come from the idea of copyrights are endless. Talent borrows, genius steals, Oscar Wilde. A good composer does not imitate, he steals, Stravinsky. Good artists copy, great artists steal, Picasso. Immature poets imitate, mature poets steal, bad poets deface what they take, and good poets make it into something better, or at least something different. Oh my God, yeah, it's all true. And we can go also to architecture. Good architects borrow, but great architects steal. And in fact, the chapelle, the famous Ronchamp, was copied pari pari, as we say in Italy, just equal, in China in 2006. But the Corbusier Foundation was able to convince or to force the authorities to tear down that replica in China, which is quite amazing. Can you believe it? So this is the ocean that we're dealing with. It's so complicated. One doesn't even know where to begin. The glossary is huge, and it's pastiche, it's counterfeit, it's mashup, it's fake, recycling, appropriating, post-production, mimesis, piracy. It all goes down to the idea of transformative copying, the idea that by appropriating or sampling something and transforming into something new, the fair use that comes from artistic transformation is thus employed and exploited. And this is kind of the same kind of ocean when it goes into logos and trademarks. You see some Creative Commons variations here. The one at the center is fair use, the PD is public domain, and so on and so forth. Many times there's been an attempt to counter the heinous TM and the hated C with other logos and icons that were equally responsibly strong. Well, sometimes piracy happens also beyond music and movies and goes into architecture. This is a particularly amazing feat. This is a Zaha Hadid building that's been copied pari pari in Chongqing, and actually the copy will probably be ready before the original, which is even more ridiculous. And Zaha famously said, what did she say? Oh yeah, it is fine to take from the same well, but not from the same bucket. So I mean, it's interesting because I don't know about you, but imitation is the highest form of flattery. Always drove me crazy. No, you can quote and attribute, and we'll get to that later. So Elaine Sturtevant is a wonderful artist, and there's an exhibition upstairs right now that I really would like you all to go and see. It was curated by Peter Illy, and he said about her that she adopted style as a medium. Famously, she copied, reappropriated, changed slightly works of art from everybody else, to the point that Andy Warhol, when asked how his process worked, said, "Ask Elaine Sturtevant, because she knows better." So it's really this wonderful way to pay homage and to reinterpret the work of her colleagues. And she said she died in May, unfortunately. I wish I had met her, because I've seen the exhibition, I've read about her, and she's quite fantastic. She used to say, there is a difference between probing originality and saying it is the death of originality. You'd have to be a mental retard to claim the death of originality. Yeah, she didn't mince words. But the idea of originality and authenticity is something that artists really think about a lot. And she was never, ever sued. And we'll see that happening with so many appropriation artists. What they do is so interesting and also so public that suing them might be something that backfires and that actually destroys the value of the so-called original. But fair use in her work was in the eye of the beholder. And the original artist does not sue the copycat artist, because the copycat is an original unto itself. Superflex is a studio from Copenhagen that was in the exhibition print out here at MoMA 2 years ago. What they did is they created these lamps in which the user could slide different images of iconic lamps. So it was a way to actually reproduce the original in a way that created a distance, but nonetheless had also some reference to the iconic original. And design patents and design copyrights is a really big issue. And I think we have some people here. I don't know if we'll be able to get to it tonight, but it's a big deal. So we've gone through architecture, we've gone through art, and here is the work of Louise Lawler. Louise Lawler, another great Brooklyn-based, New York-based artist who has been, for her whole career, photographing art in context and the way it's seen or used or appreciated by gallerists, by collectors. And she puts a frame around the context in order to define the audience's relationship with art. And there was that beautiful Seth Price essay that we sent you in the readings that also really refers to this particular topic, to the fact that art comes alive when the users, viewers, and collectors deal with it. Very interesting is also the work of Raffman and of Michael Wolff. John Raffman has been extracting pictures from Google Street View and just making them by recognizing them and framing them into his own art. And then Michael Wolff has taken small cropped parts of the same pictures and transformed them into his own work. So it's very interesting, this appropriation of the appropriation based on a sort of imperialistic panopticon view that Google Street View has been carrying on for the past few years, also with some reactions in Europe that you might know about, because the streetcars that have been going around the world certainly were visible and people knew that they were around, but they didn't announce themselves. So it was almost like a fait accompli that all of these images would be captured, and therefore the capturing on the side of the artist was also seen as possible. Of course, in music, because it's such a popular medium, works of art are amplified, and so are reactions. We have Weird Al Yankovic that we know is completely untouchable and untouched, and I'm sure he's been around for like 30 years. I think that the first parodies were at that time, and that's the secret. Parody is one of the most open situations in which fair use is recognized. But in other cases, when it's not parody, there can be some big lawsuits that can then backfire. So P. Diddy in 1997 did I'll Be Missing You, and he sampled Every Breath You Take because he wanted to write this homage to Notorious Big, B.I.G. And the police, so Sting sued P. Diddy and won. But I don't know if he won in the long term. I don't know about you. When I think of Sting, I'm like, And I think, there's consequences to doing that, so I think in this case, he was able to block the song and he won. And so every kind of royalty that comes out of I'll Be Missing You goes to Sting. Don't play it. Instead, Greg Gillis, aka Girl Talk, was never sued. And that was the music that was playing when you came in. I don't know if you noticed it, but in his 2006 hit album, Night Ripper, had 16 tracks that sampled more than 150 artists, from ABBA to Two Live Crew to Aerosmith. And Rob Walker, our beloved Rob Walker, wrote in the New York Times that Girls Talk's music is a lawsuit waiting to happen, and it never did. So very interesting how the public pressure and public opinion can block certain motions from happening. The idea of moral rights, Girls Talk is here. The idea of moral rights is something that we hope we will discuss tonight at least a little bit, but it's very French, it's very European, it doesn't really exist in the United States. And it's a recognized legal concept, and that says that although a buyer of a work of art may destroy it, he or she cannot deface it or otherwise alter it. That right belongs to the artist in perpetuity. So even if you buy something, that still has strings attached, and they are the strings from the original puppeteer. And this example that Paola Petkova, who did this whole PowerPoint, shows is Joanne Akalaitis, who decided to produce Endgame, a Samuel Beckett play, at the American Repertory Theater, but she staged it in the subway. You see that the upper left picture is a picture of the subway. And that went against Samuel Beckett's diktat that no play would ever be set without his approval and without his precise instruction. So it was really quite interesting, because in that case, the idea that the artist owns in perpetuity the rights to his own work or her own work is quite set in Europe and a little less here. By showing you this picture, I am breaking the law. I am breaking an agreement, and Nancy is really fretting. But I didn't take the picture. This is Tino Segal's Kiss. It was the installation at the Guggenheim. This performance was bought by MoMA and in June 2008. And this work cannot be reproduced without Tino coming and instructing interpreters, dancers, that together reenact many kisses from art history, from Klimt to Brancusi, to Jeff Koons, to Edward Munch. So the whole idea is the appropriation and reperformance of kisses from art history that is every time instructed directly to performance by the artist, and nobody can take pictures or reproduce or record in any way what happens. So it's, in a way, the embodiment of a moral right of sorts. What moral rights exist? Do moral rights exist also on the side of the country? Well, interestingly, there are examples of works and whole archives that have left their place of origin. For instance, the Barragan archive that was sold by several collaborators of the great Mexican architect to the Vitra owner, Rolf Feldbaum, and to Federica Zanco, who is now his wife. And Jill Magid, who's here tonight, maybe she wants to tell us about it later, artist, decided that she wanted to poke into this love relationship between Federica Zanco, Italian architect residing in Switzerland, and Barragan and the whole archive residing in Switzerland with her, and wanted to see whether she could produce an imbalance and kind of disturb the whole relationship. Now, interestingly, this happens very often. There are many archives that leave their place of origin, especially if the place of origin is somewhere like Italy, I can say it because I'm Italian, or Mexico, and go into the care of sometimes private institutions that do a great job at maintaining them. The important thing is to make them available, open access once again. If instead they become closed access, then I can understand. But it's really interesting because there are moral rights that are claimed, and we can talk also about how the restitution of so many works of art these days from museums is based on the same concept sometimes. Again, John Raffman and the idea of looking at the panopticon and the internet is moving also the whole idea of copyrights and patents and trademarks and moral rights into privacy. And it's a really complicated matter because, as Rahman himself said, the unspoken reality or challenge in the question of authorship is the fact that Google has claimed ownership of all it has purveyed and filmed with an unmanned camera. Moreover, the sheer vastness of what Google has photographed and placed a copyright sign on is an imperial claim so vast that it mirrors England's claim to an empire upon which the sun never set. So this is amazing. One can just like stomp a sea onto the world and be done with it. What is the deal with all this? Maybe the matter that would resolve all the claims would be simply attribution, homage. Maybe some people could be just swayed by a recognition of the source, knowing that somebody is copying your work knowingly and admitting to it could be a way to go. This is what Maria Popova, who's here also tonight, did in 2012. She tried to add a symbol to the panoply of the symbols that we saw before that deal with intellectual property, and that was the Curator's Code. It was a symbol that one could add to attribution that was really targeted and tailored for the new culture of quoting and referring and attributing on the internet. And I don't know where that is right now. Maybe you'll tell us later. But it was an attempt to really clarify the fact that in many ways it's a matter of respect. We know that it's also a matter of money, but respect could go a long way to at least initiate a dialogue. There are many copyright horror stories that I won't go into too much detail now because otherwise we won't have any more time, but you remember probably Celera's attempt to copyright, to patent, actually in this case, the whole human genome, not only the whole human genome, but also parts of it. And then in the year 2000, Bill Clinton, the president at that time, said that the human genome was not patentable. And all of a sudden, Celera's stocks plummeted, but they're still working on patenting at least different parts of it. And then, really hilarious when Bikram Choudhury tried to patent the process, the sequence of Bikram yoga, which, as you know, is performed. They are like old yoga moves that have been around for centuries, but they're performed in a special sequence at 102 degrees. God knows why, but some people might love it. He tried to copyright, not patent, the process and the sequence. And I don't think he made it. Yeah, he said, hold that pose, federal judge ruled that Bikram yoga cannot be copyrighted. And then, of course, the happy birthday song. In theory, if you and I sang that song outside of our family, we would have to pay Warner Chappell, which is the company that actually owns the copyright, we would have to pay them a copyright. And it's something that has driven everybody crazy forever. To talk about all these matters and more, and as you can see, it's really a big meatloaf, tonight we're going to have, bam, copyright on it. Tonight we're going to have these great speakers. We're going to start, you're going to just like make it all clear for us. The first is Pippa Longard over here. Pippa is a deputy director and lecturer in law at the Kernachan Center for Law, Media, and the Arts at Columbia. And she's an expert in intellectual property and the arts. The second to speak will be Nancy Edelson, our own Nancy Edelson, General Counsel of the Museum of Modern Art. And we have gone through so many battles together, from video games to, I don't even know, but she's really like an expert. Being a General Counsel at the Museum of Modern Art is pretty adventurous, I can tell you that, and she will tell you more. And she also has a past before the Museum of Modern Art, so you'll see. After, we'll have Fred Benenson. Fred is now data engineer at Kickstarter, but he used to be data engineer at Creative Commons. Were you data engineer? Data engineer also that? Activist. He was an activist. Forget data engineer. But you know what? Data engineer is activist. In that, there's a beautiful essay amongst the ones that I sent you that is about the figures of the DJ and the programmer changing the way we deal with intellectual property. So you were indeed an activist with Creative Commons since the very start, and he also has quite a few tales to tell. And last but not least, of course, is Artie Verkant, who is a post-internet artist and who deals with his art he deals with the role of image reproduction and dissemination, the idea of dispersion that is so important to art today. I went a little over, but not too much, so I would like to introduce to you Pippa Lundgaard. Thank you.